talking about. And do me a favor, you said nearly every student make a list of the ones who don't. Uh-oh. I'm glad to be here. What's the old vaudeville joke? I'm glad to be anywhere. Some of this will be just what, I got 10 minutes, right? Your program starts at 9, right? Okay, I'll try to talk faster. First, I want to give credit to the people that started this program. A lot of people still persist in the notion that I started the program. I didn't. Tom Christopher was dean at New Mexico Law School, and he saw the need. There was a visiting professor from Boston College, Fred Hart, and he said, as long as you're going to be out here for a year, why don't you do something useful and start a program? Fred did start the program. The associate dean, Hunter Gear, who's still alive, he's frail, but he's up in the North Valley someplace. He actually put the program together, and of course, as always, the one who did all the work was the secretary, Mary Kroom. She was Hunter's secretary. And they changed history, not just in New Mexico, not just for Indian people, because they showed an alternative way of assessing law school applicants, and that is by trial by combat. If you made it through 8 weeks of PLSI, then that would overcome maybe a weak LSAT score. Another thing remarkable about that is Fred was on the LSAC board, for Christ's sake, and here he was undermining them. So let's not forget, those are the people that do this. I just failed to wreck it in 40 years. All right. One of the reasons you invite old guys like me is we tell you stories of the way things used to be. And then people say, oh, well, old people, they always say stuff like that. No, there's some relevance in doing it then and now. My generation was really the first one that went to law school and went to college in numbers, and the first one that went to law school in any numbers. And when we got out of school, we faced a unique challenge, and that is, where do we fit in? Can't all of us go back to our reservations? You know, our students, graduates, had a hell of a time getting hired by their tribes because they were all represented by white law firms that were very jealous. And the way you stay in business, you don't hire some kid who in 5 years is going to take the contract away from you because that's his tribe, you know. And these guys aren't stupid, that's why they're rich, right? So they didn't get a lot of job offers, and there are complications when you try to go back to your own community in a different role. These people saw you when you were kind of snot coming out of your nose and headstone, and are they going to see you as a lawyer? It's a little difficult. They still see that kid. And unfortunately, part of our conditioning the last couple hundred years is white lawyers always know what they're talking about. Indian people don't know what the hell they're talking about. So they'll look, what do you say? That's another story entirely. So when we got out of school, people used to say, oh, Indian people resent educated people and they reject them when they come back. Well, that's crap. If you come back as a know-it-all, yeah, you're going to earn your rejection. Now is that unique to Indians? I don't think so. If you come back and make a place for yourself, it's not going to be a problem. Me, it's different. There's no place for me. my place is the burr under the sun, so I didn't worry about that. But we had to fit in, where do we fit in nationally? In those days, tribal chairmen were the cornerstone, keystone of everything. We didn't make a move without making sure that we had our tribal chairman flanks covered. And that was often just NCAI, or then there was this ill-fated organization called the National Tribal Chairmen's Association, which I think you could compare favorably to the Albuquerque Balloon Fiesta. But we had to cover our flanks. And national, there weren't very many national organizations, and the ones that were, the ones with a tribal constituency were considered the more legitimate. There was a real sense, as in the old Christian church, of apostolic succession, and that is, those chairmen, they're the ones that got elected. They're the ones that have to go back and say, here's why this is being done. You don't answer to nobody, and so these people should know what you're doing. And we respected that. That made sense. It was a hierarchy we could understand and accept, not only because we were scared not to, but because it worked. It was right and just. Move the clock forward. I hate to say how many years it was. What was that? 1971. I left law school. That's at 53 years ago. Your grandparent, well, never mind. Move the clock forward, and NCAI is, with all due respect, nothing. Why is that? NTCA is gone, and there is a national organization for every conceivable category of Indians on this earth. You name it, there's a national organization, which means that the power has shifted to networks. You know, with the cliche is, we take the best about culture, so people graduate from schools knowing that networks, the two mantras, resilience and networks. Unelected, responsible to absolutely nobody, and let's say a sometimes toxic level of self-esteem. And it's really, I remember in the last 2 administrations ago, a bunch of this network decided that, and they had all the bases covered, White House and all of that. They're going to have an indigenous youth initiative, and they did not include a single Indian organization in their planning or in what they did. It was all their network. And they didn't do a damn thing but have events, and then they disappeared. You know, come on, we deserve better than that. So, look out for networks. I know some of them you're going to, I mean, there are natural affinities. People you went to school, I understand all that. They're not necessarily bad. Just recognize the pitfalls, the hubris of deciding that you and your college friends and people of your generation are better qualified than people who have to stand for election in an Indian community. We've got to still have a sense of hierarchy and entitlement. Who is entitled? You know, entitlement's another mantra. The entitlement that comes from being responsive and responsible to a community, which most of us are not and never will be. Okay. Indian law. I appreciated what you said. Appreciate what you said, what he said. I ran into an alum at a meeting. And by the way, and I'm speaking on behalf of Rodina. How many graduates, how many people have gone through PLSI?
Over 1,500.
Oh, it's gotta be well over 50. I
Almost.
just raised it to 2,000. Hey, it's 50 years, man.
It's about 1,600.
Oh, get out of here. It's bigger now. Anyway, I used to say, when I run into somebody, I used to say to PLSI, if I see you someplace, conference, airport, or something, just come up and tell me who the hell you are, what year you are. Otherwise, the first 10 minutes is me trying to fake you out. Because I had too many times of saying, well, how's school? Well, I've been in practice for 10 years. Or, so what are you doing these days? Well, I was in the program last summer, so I'm going to law school. Well, you know, come on. So, I said, what are you doing? Working for the tribe. Oh, how do you like it? I'm a little disappointed. Why is that? I thought I was going to be practicing Indian law. Well, what are you doing? I'm reviewing contracts for the tribe. Yeah, that is Indian law. I mean, Indian law isn't what do you do with the sheeps when grandma dies. It's not just that. I don't want to make fun of that because that's important too. But that's Indian law. You practice Indian law. When we took the contract to revise and update the Cone book because the task force they set up in the Nixon administration wasn't doing anything. They were going to conferences and weren't getting anything done. So I called Reed Chambers and said, I'll get it finished. I'll get some law professors and we'll finish it if we can have the copyright. He said, just do it. So we did. We've been doing it ever since. It's not necessarily the scholarship that I would have written, but then maybe that's a relief because I'm not a scholar. But there's one law professor, Indian law professor, who is like the others. And I said, how come you never wanted to be part of this Cohen project? And he said, I don't want to be part of a project that gives the tribes bad news. What? He said, Indian law isn't going so good, and I don't want to be the one that tells them the bad news. And I said, you know, in the old days, we used to send out scouts. The scouts out there, and they see 50 heavily armed Crow Indians heading for our village, and we go back and they say, how is it? Oh, no problem, man, everything's cool. I didn't want to upset them. Hey, that's what we sent you out there for. Why do you think we sent you to law school without telling us what's coming down the road? What is that big thing with blinking lights? That's a bus that's going to run over you. So in addition to networks, orthodoxy and scholarship and practice, be careful of that. You are, many of you, are now or just have recently been through a, remember in history when they talked about the Middle Ages and they had these scholars, they call them scholastics, and the big thing, whenever somebody says scholastics, these were the guys that said how many angels can fit on the head of a pin. That's what we have for the most part in Indian law scholarship. there were two of the saints of Indian law of the era. The Supreme Court issued an opinion they didn't like, and so they imperiously said, the Supreme Court doesn't understand Indian law. Well, see, the thing is, they make it. So it's whatever they say it's going to be. Not what Cone wants it to be, not wanted it to be, not what I want it to be, not what Indian law professors want it to be. It is what they say it is. We are facing, you are facing, me, I'm retired. You're going to be facing an era, this thing isn't going to get worse. This isn't Joey going to walk in with a big majority and have a majority in both houses, and then all the MAGA people are going to say, shit, and go back home and start watching reality TV again. No, I'm going to be classes, but this isn't going to be over quickly or easily. And so what you're going to be facing, I'm sorry to tell you, is an era where we have to scramble to hang on to every piece of ground we've got. One of the mistakes in federal Indian law is they talk about it as if this was a couple hundred years of unbroken Supreme Court defense of it. John Marshall said, and with only a few exceptions, like during termination, anomalous exceptions, otherwise it was the courts fighting for the Indians. If you look at eras, you see that it was not quite so good. In fact, with few exceptions, the anomaly was the period from the late 50s up to middle 70s, when the Supreme Court liked us, the Warren Court. After that, we got our asses kicked over and over and over again, and it's coming up. Clarence Thomas doesn't like Indian law at all. We should be looking at every word that guy has ever written on the subject to see what he's going to say when the inevitable landmark case comes before the court. He does not like the category of federal Indian law. Now, the way I interpret it, and again, I'm not a scholar, I'm too lazy and disorganized to be a scholar. But I know that one of the things, due to some bad scholarship, there's this mantra that the plenary power of Congress gives Congress unlimited power. Because if you look up, what?
No, I was gonna have her take a
What
picture.
did I do? If you look up plenary in the dictionary, it says unlimited. Well, come on. That's like Superman in the universe without kryptonite. There's no unlimited power. Plenary means like when you have a conference and there's no breakout sessions, everybody's in the big room doing business. They have all the power that they have, which may not be very much. It doesn't mean when you have a plenary session of this meeting that you all can walk on water and fly and, No. It just means you have all the power that it says in your charter that you have. People trace the plenary power. I actually wrote an law review article on this. Typical of my scholarship, I think I cited two cases. I had two footnotes, and both were citations to other things that I had written. Hey, I don't care what other people think. In Kagaba, the court basically said, we're sick to death of having to come up with an enumerated power every time Congress wants to legislate about Indians. So we're going to call it plenary power, which means you have all the power you need to legislate on the subject of Indians. On the subject. It's not power over Indians. Now, course, the question from the scholars is, well, boy, it sure as hell looked like it. Yeah, it did. Because there's really no way to draw that line. Nevertheless, if you are, excuse me, a structuralist or something, it means on the subject of Indians. That's an important distinction. If Clarence wins, his side wins, then that means they're going back to Congress having to find an enumerated power if they want to legislate on the subject of Indians. And what are the enumerated powers? Obviously the Commerce Clause. The treaty power, even though they're not going to make new treaties, although some dipshit writers have suggested they go back to treaties. Oh yeah, that's practical. The VI is going to have a branch of treaties, send a bunch of GS-12s out. Give me a break. The treaty power, Commerce Clause, Indians not taxed. Well, I don't know how they could turn that into a useful enumerated power. And they say that federal ownership of land. In other words, they're going to have to scramble to preserve what we want there to be in Title 25. That's what you all should be looking at in your spare time, is what is Clarence going to say? How is he going to take it away? What's his opinion going to look like? I always thought if I taught Indian law, the final exam would be one question, and that would be, if you could write the opinion in Worcester versus Georgia, write the opinion Marshall should have written. Because everybody's, oh, Marshall sold us out. Marshall saved our ass, man. Yeah, he put all other stuff in there, but it could have been worse if he'd written something different. So we got to be realistic. All right, oh man, I'm taking in some of this time. All right, I'll wrap it up. Someday, what does this say? Oh yeah. I used to say to PLSI, someday you're going to be in the room, and everybody in the room is going to want to do something. I think it's a great idea, and you, as their lawyer, will be expected to respond to this great idea. And you have misgivings, maybe about the legality. Maybe you're gonna have trouble finding a way to do it legally. Or you're gonna have misgivings about whether this makes sense. Remember the time when tribes were on the roll, winning some good things, and the beginning of that backlash that Chuck Trimble writes about. And dear sweet people in, oh, I know, a law professor from the University of Wisconsin wrote an article saying the Oneida people in Wisconsin should really have jurisdiction in the boundaries of their original reservation. And that was one of those great Indian law things. Yeah, right on. And so they talked about it. Well, the original boundaries of the Oneida reservation takes in this little enclave called the City of Green Bay. Okay. Now, technically, in the scholastic sense of angels standing on the head of a pin, the guy was right. In the sense of, you gotta pick your battles, man. He was wrong. Now, I don't know if they ever really tried, but sometimes tribes are led or asked to do things that are not in their best interest. And as a lawyer, it's not, yes, I'll find a way to do it, even if it's the stupidest thing anybody has ever suggested. You are obligated in exchange for your privileged position in society, which is true. That confidentiality thing, they don't give that to just anybody, is to speak up. They're not just paying you as a mechanic, they're paying you for your advice and experience. And it may make you unpopular, but what they need from you, just as what was needed when we sent out scouts, is give them the bad news. Tell them there's a downside to this, because they don't always look at things that way. And I would urge you to do that. And there's no warranty on this advice. When they fire you, you can't come to me, because I got fired from my last job for talking out of turn. But think about it anyway. I've talked way into somebody else's time. That's too bad. You shouldn't. All right. Thank you very much for your attention, and I appreciate being invited here. And so there we go.